Peace, love, and law. Today I will be going over the Contract Act, Chapter 166 of the Belize Laws. Now, this is a very short act. As you can see, it's 13 pages. You can see right here. And out of the 13 pages, the first, second, third, fourth, fifth, it's like the first 4 pages are just, not much. But we're going to go over this very short. But you see what I did? I actually did a simplified version of it. And how I did that was I gave ChatGPT a character, made him into this 20-year veteran in law, and I had him interpret that. So I want to go over the simplified version right here. And as you can see, it is going to be only how many pages? I think it's 2, 3, 4, 5, about 6, 7 pages. So it starts out very simple, as you can see right here. See, it's part 1, goes through the title, 2 or more joint covenants and agreement between persons. And I would recommend that you read this first, right? And if you don't understand what this is saying, right, then obviously you can look at this, right? So in terms of joint contracts, right, it talks about the deals with contracts made jointly with 2 or more people and the effect of one person surviving the other. So it's basically saying if a contract or obligation, like a bond or a promise under seal, a promissory note, is made with 2 or more people together, it's automatically assumed that the obligation continues for the benefit of the surviving people. If one dies, the obligation also benefits any person who inherits the right to sue under the contract. If not otherwise stated, this is how the contract must be interpreted, and this applies to contract made after this date. Okay. So basically the interpretation here is this prevents legal complication when one of the joint party dies. Survivors don't lose their rights, and successors can even enforce the contract. This is an interesting section, section 3. See right here, section 3. It says covenants and agreements between a person and another or others. Okay, so if we read it like this, see, it says here, the original version, any covenant, whether expressed or implied, or agreement entered into by a person with himself and 1 or more other persons shall be construed to be capable of being enforced in like manner as if the covenant or agreement had been entered into with the other person or person alone. So if you notice, it says right here, what is it saying? Simplified, right? It's simplified. All this legalese right here is confusing. Well, a person can legally enter a contract with themselves or other people or with your person, right? And the contract will be treated as if it was made with the other people only. This applies to both past and future agreements. So the interpretation here is that this clears up what might seem strange. Someone signing a contract as both a trustee and a beneficiary, for example, although that's not the way you're supposed to do that. It's if you're a trustee, then maybe you're the grantor and trustee, or you're the grantor and beneficiary, but I don't know about that beneficiary and trustee example here, but basically, this provision ensures that the law sees it as valid. So, as you can see, this section applies to covenants or agreements entered in before the commencement of this. So, this is a simplified version. And right here, this is section 4, time and equity. And right here, it's essence of a contract. It says stipulations in a contract as to time or otherwise, which according to rules of equity are not deemed to be or have become of the essence of the contract, are also construed to have effect at law in accordance with the same rules. So what's it saying? So basically equitable rules is about time not being essential not being essential apply also in law. So simplified, it says if a contract doesn't state that time is essential, then the courts must follow equitable principles, not treating timing as critical unless fairness demands it. So basically the interpretation here is that this stops people from canceling contracts just because something was late, unless time was clearly essential. It promotes fairness. So section 5 talks about certain agreements must be made in writing. See right here, statutes of frauds, that's what they call it. No action shall be brought whereby to charge any executor or administrator upon any special promise to answer damages out of his own estate, makes sense, or the defendant upon any special promise to answer for a debt, the debt, default, or miscarriage of another person, any person upon any agreement made in consideration of marriage. So basically what it's saying right here is that you can't, right here, see, it says here, you can't sue to enforce any of the following unless the agreements is in writing and signed. So a promise by an executor to pay out of their own estate. Isn't that interesting? Isn't that interesting? A promise to pay someone else's debt. Okay, it has to be in writing. A promise made in consideration of marriage, a contract that takes longer than a year to complete. Interpretation, this codifies part of the statutes of fraud. It protects people from false claims by requiring written proof for risky or important agreements. So it says here, validity of written guarantee, section 6. No special promise to be made by any person to answer for the debt, default, or miscarriage of another person, being in writing and signed by the person to be charged therewith, or some other person by him thereunto lawfully authorized, shall be deemed invalid to support an action, or a suit, or other proceeding to charge a person by whom it was made by reason only that the consideration for such promise does not appear in writing. You see, so you see how complicated it gets right here. The way they write right here is like they, I don't know, it's like they're purposely making it complicated. You know, because why? How do we know that? Why? Because of this, simplified. So basically, the guarantee doesn't need written consideration. A written promise to answer for another person's debt is valid even if the consideration is not written. So then check this out, right? So let's say there's a debt that is owed to the electrical company, and then you write a promise to the electrical company to pay that debt for them, for that person. It should be valid according to what this is saying. Well, it's an example. So here's another simplified explanation here. It says a signed written guarantee is still valid even if it doesn't say what the consideration was, why the promise was made. That's why many of the instruments that we sign can be converted into a security, because it may imply it may definitely say that one is promising to pay another one's debt, but it doesn't say what's the consideration. So obviously you don't need a lot of information on there for it to be taken as interpreted as it being an actual promise or guarantee. So section 7 says rights of a surety, person who pays another's debt. There you go, see, it's right here, see, rights of a surety, section 7. Now again, you read this here, see, like, okay, every person who, being surety for the debt or duty of another, or being liable with another for any debt or duty, pays such debt or performs such duty, shall be entitled to have assigned to him or to a trustee for him every judgment, specialty, or other security held by the creditor in respect of such debt or duty, whether such judgment, specialty, or other security is or is not deemed at law to have been satisfied by the payment of the debt or performance of the duty, and such person shall be entitled to stand in the place of the creditor and to use all the remedies, and if need be, and upon a proper indemnity, to use the name of the creditor in any action or other proceeding at law or in equity, in order to obtain from the principal debtor or any co-surety, co-contractor, co-debtor, as the case may be, indemnification for the advances made and loss sustained by the person who has so paid such debt or performed such duty, and such payment or performance so made by such surety shall not be pleadable in bar of such action or other proceeding by him. So how many people right now, with degrees, bachelor's and master's degree in all these subjects, and for that is not related to law, when I read these, that we look at them as very, very intelligent people, and they read, do you think they would understand what this just said? Because this takes a special practice training, or you better know some foundational principles right here, and in order to understand this. So this seems, now let's simplify. There you go, see. So a surety, this is the original surety who pays someone else's debt, can claim all the legal rights and remedies the creditor has. This is simplified right here. If you guarantee someone's debt, right, and you end up paying it, this is what you can do. You can take over the creditor's legal rights. You can use the creditor's name in the lawsuit to recover the money. Wow, that's interesting. So basically, let's say a creditor, the utility company sends a bill to your person, and then you promise to pay it in behalf and for your person. So they're supposed to use that promissory note as a security for that debt, and then it is supposed to be utilized as an asset to be, I guess I would say, adjusted in the accounts receivables, so that it can then adjust the liability of the principal debtor. So that's what I'm getting from this. So now it says here, you can recover from the person who owes the debt. So now once you pay it for the debtor, and it's between you and the debtor how the debtor is going to pay you, right? But if you already have an agreement through trust with the debtor that you're going to pay everything for the debtor, because the debtor already conveyed everything to you. So let's say your person conveys everything to a trust and appoints you as trustee. So now you now have to indemnify, as the trust, or on behalf of the trust, has to indemnify the grantor, because it's the all caps person that is granting it, right, to the trust for a benefit, right? Because in the public it's all fiction. It's not us. It's fiction. It's our person. So we can pay it with our labor, right? We're performing here in the private, and in the public, which is the commerce. They need some form of security always, so we give them that by our substance. We give substance for as value, and they in exchange reciprocate that to our beneficiary, to whoever we choose to be our beneficiary. So our beneficiary should be getting credits, or at least a settlement on the account. So it says here, but you can't claim more than each other's co-guarantees, guarantor's fair share. So interpretation, this is the principle of subrogation, ensuring fairness and recovery for someone who has stepped in to pay someone else's obligation. Section 8. See right here, loan settlements. Now right here it's talking about character references must be in writing. So remember, it's always in writing. You got to make it in writing, because that's how it goes, and how it becomes something, an official public record. And once it's an official public record in the eyes of the law, it is fact until it has been rebutted or updated, right, or canceled, But Says here, the original says this: you can't sue someone for misrepresenting another person's character to get credit, etc. Right? So let's say you use somebody else's security. It says you can't sue someone for misrepresenting another person's character to get credit, I guess, unless it's in writing. So, okay, let's see. It says if someone lies in a reference or assurance to help another person get credit, there you go, you can't sue them unless it was written and signed. That makes a lot of sense, right? Interpretation: this avoids litigation based on verbal gossip or hearsay. Written proof is required to sue over a misleading character reference. So right here in part 2, it basically talks about infants' marriage settlements and other contracts, talking about marriage settlements by minors. An infant under 18 may, with court approval, settle property upon marriage. Simplified: a person under 18 can make binding property settlements when getting married, but only with the court's permission. Interpretation: this protects young people from exploitation while allowing legitimate property arrangements like prenuptial agreements. Section 10, how court approval works. Okay, it says here the court can approve a minor's marriage settlement via simple petition, not a full lawsuit. And the court may require notification to interested parties. If no guardian exists, the court can decide whether one is needed. Section 11 talks about minimum age for marriage settlements. Section 9 and 10 does not apply to anyone under 17, basically. So Section 12 talks about loans and contracts by infants are void. Any contract by minor under 18 to repay a loan or buy non-essential goods is automatically void. Now here are the exceptions. Contracts for necessaries, food and shelter. Contracts allowed by law or equity. Section 13 right here talks about no enforcement after coming of age. So what it's basically saying is even after reaching adulthood, a person cannot be sued on a promise they made while they were a minor. Isn't that interesting? Even if they later confirm it. So if you did some promise as a minor, to pay whatever, that's null and void. Can't do that. So soliciting, section 14, soliciting false affidavits from minors. So simplified. And I guess what the definition of minor, right? What is that? Obviously we assume it's just 18, but we can look into this some more, and we can find that minor is basically a person who is unable to manage their estate. So anyway, simplified. If someone asks a minor to sign a sworn statement, like an affidavit, related to a loan without the court's approval, they can be fined or they can be jailed. Section 15, promises to repay, void loans stay void. So this is interesting, right? I mean, this is like when, like for example, like when you'd sign a bail bond, right? And if it's, if you're being considered to being a minor, meaning of unsound mind, and then they don't let you out unless you give a bond. Well, it sounds like a false affidavit, because they make you sign a promise to pay a fictitious entity against your will for a victimless crime. So, but what they're trying to do is they're basically trying to manufacture with your help an instrument, a negotiable, a commercial instrument, which can be used in a financial setting. So this is very interesting right here. So anyway, promises to pay, section 15, promises to pay, promises to repay void, loans stay void. Okay, simplified. If a person tries to repay a loan they took as a minor, that promise is completely void, unless it's a new loan. Part 3 talks about gaming contracts and securities, talking about gambling debts are not enforceable. That's your problem, not their problem. Simplified. Any legal document based on gambling or betting is considered to be based on an illegal consideration and is therefore unenforceable. enforceable. Section 17 talks about gambling contracts being void, simplified. All contracts based on gambling or betting are null and void. No one can sue to recover money won or lost from a bet. The exceptions, this is lawful games and competitions like sport prizes. Section 18 talks about promises to pay for gambling losses that are void. So simplified, it promises to repay gambling losses or pay fees related to gambling are not enforceable in court. There you go. Section 19, exception for licensed gaming. So this is simplified here as the above rules don't apply to gaming or lotteries covered by these right here. So we are on part 4, frustrated contracts. So it's a section 20, effect of frustration. So simplified, if a contract governed by English law becomes impossible to perform, that's what you consider frustrated. The law prohibits for fair handling. So the law provides for fair handling. My bad. Money already paid can be recovered. Money due no longer has to be paid. Courts can allow expenses incurred to be deducted. If someone received a benefit, example goods and services, the other party can get compensation for the value. You see this? Because see, check this out. They're telling you right here, if someone receives a benefit, right, and this benefit is goods or services, right? These are examples. If someone receives that, that means the one that gave it to them, the other party that gave it to them, can get what? A compensation for that value. So what are they saying? That these things right here, these benefits that they get from us, right? For example, they're getting promissory notes and they use it as bonds, and that is adding credit in an account, so that's value. You know what I mean? So basically what I'm trying to say is that when we give them goods and we give them our services, then we are the party that can get compensated for that value that we give them. So it's always looked upon mainly like they're the one giving us value, but in reality it's a reciprocal thing. Actually, we give them value from the private to the public, and then they're in the public, they're supposed to return that for value. So yeah, there's that. So anyway, it continues. Overhead and personal effect can't count as expenses. Insurance payouts don't count unless required by contract. Section 21 talks about when and how the frustration rule applies. So these frustration rules rules apply only to contracts when the frustration event happens on or after this date right here. Okay. The rules apply to government contracts too. Okay, so that means it's any contract, but they're saying government contracts as well. If a contract already has a frustration clause, the court will follow that first. You see what I'm saying? Again, if the contract has already something in place, the court must follow that. The contract becomes the law unless it is something illegal or unlawful that they deem that they don't really want to mess with. But the contract makes the law. If part of a contract is fully performed, that part is treated as separate and not frustrated. The rules don't apply to these right here. Don't apply to insurance contract. Don't apply to certain sale of good contracts or charter party shipping contracts. So there we go. That's it. That's all it is. That's all she wrote. But you can download this, right? You can download this right here. Just go to the website of the Attorney General of Belize, and you go. Let me show you. I'll show you. Let me show you how I find this. You can find all of them. Attorney. Let me see. AGM. There you go. So once this pops out, you go right here, Laws of Belize, and you click this here. See, bam. So once you go there, see volume 1. See, it starts off Cap 1. So you just scroll down, try to find it. There you go. See, volume 6. It has a criminal code right here. This one's really good. So you have family court, inferior court, district court procedure, summary jurisdictional offense, summary jurisdiction procedure act. So really cool stuff right here. If you come here in volume 8, see, there's more stuff right here. So let's see volume 9. And I think it will be in volume 10. See it here? Contract Act right here. Bam. And this is a good one to read. Crown Proceedings Act. Right? This talks about how the Crown, you know, the Crown can be taken to court, and these government officials are acting on behalf of the Crown. Debtors Act, this is another good one. This is how they get people in jail. Right here. This is the one I'll be studying soon. Tort Act. But that's all for today. Thank you much for watching. If you want a copy of the simplified version right here, right? If you want this, just reach out to me. Send me a message. I don't know. Just send me put a comment on the video. What you can do is just comment your email address and say, hey, send me the simplified version of this, and I will do so. Until then, peace, love, and love.